Good evening, everyone. My name is Kevin Freitag. My firm, Murphy, Hesse, Toomey & Lehane, represents the town of Milton, and I've been appointed as lead counsel for the town. And I'm here tonight to give a presentation regarding public records. I suspect that this presentation will be about a half an hour long, and then if there are any questions at the end, I'm certainly available to try to answer those. My understanding is that this program is being recorded and will be made available to the public on the town's website. Also, the presentation that is being shown is also going to be made available to the public on the Town of Milton's website. So, we'll start at the beginning, the history of public records law. The Commonwealth has had a public record law of one sort or another on the books since 1851, which was always intended to provide transparency to the public and the ability of the public to be able to inspect and copy certain governmental records. In the 70s, the Massachusetts General Court enacted and signed into law what we now think of as the public records law, which again codified the public's right to have the ability to inspect and copy certain types of governmental records. Those laws were amended into what is essentially their current form in 2016. And in 2017, the Supervisor of Public Records, which is a office within the Secretary of State's office, created a set of regulations which were meant to sort of fill in the gaps in the public records law to provide the public with a better understanding of how they might seek public records, but also to position and enable the Public Records Division, which is headed by the Supervisor of Public Records, to have a better understanding of how to enforce the public records law. So the public records law itself is found in a number of different areas. It's found in the general laws in Chapter 66 and some of the sections thereunder. The ones that are primarily cited to in the representation of towns are sections 10 and 10A, which relate to the production of public records, and 10A, which relates to determinations, among other things, of violations of the public records law. General laws, Chapter 4, Section 726, has a number of definitions and exemptions, which all relate to the public records law, which we'll get into in a bit of detail in a few minutes. And then the regulations, which again sort of fill in the gaps of the public records law in the general laws, are found at 950 CMR 32. And again, they're extensive, and they really are sort of the fabric of the public records law. They really deal with the nuts and bolts of how the public records law works. So, the public records law applies to all governmental bodies or instrumentalities of the executive branch, whatever they may be called, as long as they are intended to be embraced within its all-inclusive terms. And basically what that means is that almost every public body and governmental agency that you can think of falls under the jurisdiction of the public records law. There are a few exceptions, which are the legislature, and to some offices of the some offices of the trial court. So if you were to send a public records request, for instance, to the legislature or aspects of the judicial department, they would be under absolutely no obligation to respond to your request. What is a public record? The answer is almost everything is a public record, depending on who makes it or who receives it. But if you're specifically looking at the form that a public record might take, it's extensive. It includes books, papers, recorded tapes, financial statements. It's basically any sort of recording that might be made that is either produced by or received by typically the government or a public body as a subdivision of our state government. So it's incredibly broad. And again, what you should be thinking here is that the form is not as important as the sort of the concept, which is a recording of something that's either made by or received by the government. So things like texts or tweets or any other type of social media post that you might think of could all be public records based on the circumstances under which they were sent, or under which they were made, or under which they were received or created. And when thinking about what is a public record, I think it's helpful to ignore the source or the destination of the record. And by that I simply mean that simply because for instance, a member of the planning board sends a text to a fellow planning board member about a site plan approval application that they've received, and they send it on their phone. It's not a work phone, and they send it from their a text message, or perhaps even using some other type of social media. They send it directly to another member of the planning board, but it specifically relates to what they do as a planning board member. That communication, that information could be considered a public record. So it's not as if to say that, well, if it's only a public record if someone sends it from their Town of Milton email account, for instance. Certainly those things would be presumptively public records. But if someone were to send something from their Hotmail account, but it related to their position for the Town of Milton, then that particular record, that email, could also be considered a public record, notwithstanding the fact that it came from their personal or even their work email account. So it's important to know that when an analysis is being conducted, either by the supervisor of public records or by a municipality that's considering whether or not something is or isn't a public record that ought to be produced in response to a public record request, the presumption should be that everything is a public record. And typically that's sort of the starting point of the analysis, particularly when you're dealing with municipalities. All records that are maintained by a municipality are presumptively public. And again, that includes things like private emails, even if they were sent by an individual in their capacity as, let's say, an employee of the Town of Milton or a member of a board of the Town of Milton. All of these things can be considered public records, subject to the application of certain statutory exemptions, which we'll get into here in just a bit. So the breadth of the definition of a public record, I think, suggests some best practices, which are things like separating as best one can their public from their professional, from their private life. And that is to say, if the Town of Milton has provided you with an email account, you should use that email account for all town business. And if someone were to reach out to you and you account or your private or personal email account, you ought to respond to them and say, please contact me using my town account. That way it's easier to determine what is a public record and what is not. And that way too, particularly when you're using town email accounts, the town has sort of an infrastructure or a system in place to maintain and keep copies of all of its, for instance, its email, but certainly other types of records. And so that in that instance, then you're capable of relying on the town to maintain its own public records and not putting yourself in a position where you might be subject to some question about whether you have properly maintained a file or deleted an email that might have been a public record when it ought to have been preserved in a certain manner in accordance with state law, because it was in fact a public record. So use your town email account if you have one. That's certainly the best practice. Obviously the flip side of that is don't conduct town business using personal email or other social media, and don't delete any email associated with town business that you have. Now, as I said, there are a number of exemptions that apply. There are a category, or there is a category of exemption that is sort of commonly referred to as sort of a catch-all or statutory exemption. And what that means is that there are some records that, pursuant to state law, are not public. So student records, for instance, are not public records. There is a statute directly on point that defines what a student record is and makes it clear that that is not considered a public record. So if the town of Milton or the school department were to receive a public record request for, let's say, a student's record, there would be a number of laws that would come into play. The public records law would be one of them, because that would be the law under which the request had been made. But also the student record law would come into play, because student record law specifically ordains student records as being exempt from disclosure under, among other things, the public records law. And there's this sort of interplay with the public records law and its exemptions, which are all found in this section 7, subparagraph 26, and some of these other statutes. So that section 726 sort of points to, in a way, many other areas of Massachusetts state law, including criminal records, which are sometimes referred to as Corey, or student records, and says if any of these other statutes in Massachusetts say that things are not public records, then that satisfies the public record statute as well. The next exemption that I've sort of identified here, which is probably the most common, is exemption, it's exemption 726C, and that is just to suggest that I think there are several different exemptions. C is one that is sort of invoked, I would say, most frequently in response to public record requests, and it really pertains to sort of two categories of information: records that contain information of a highly sensitive or private nature, and also personnel records. On the privacy piece, where this comes up from time to time is maybe a coworker at town hall in Milton sends one of their colleagues an email that says, my son Tom is very sick today with chicken pox, and I'm going to go home and take care of him. If someone were to make a public records request for records, and that email, because of the date on which it was sent or the person that sent it, fell within the scope of a public records request, that information about the person's child and their physical or their physical condition or their health would be exempt from the public records law. So while the record itself might be a public record in the broad sense, that information could be redacted from the record before it were produced. When it comes to personnel, that category of information is somewhat more challenging to define. It typically includes information that pertains to an employer's decision to hire or terminate an employee. However, during the pandemic, there was a bill, the police reform bill, that was enacted that sort of carved out from what was sort of typically thought of as the personnel exemption to public records, a section of records that relate to police officers and investigations of police officers, particularly like internal affairs investigations. And while under the previous version of the law, those records were regularly believed to be exempt from production under public records because they related or were considered personnel files or personnel information, the legislature has now said specifically when it comes to police officers, information related to them stands apart from other types of personnel information. And so public records requests for instance, investigations of police officers are public records. Now, they may contain information that is not, or that is exempt from public records. Perhaps they contain some health information, as the previous example just sort of touched on. Or maybe they contain, names and addresses or some other very personal thing that might be exempt. In a case like that, you would likely see redactions to an investigative report, but the report itself would be considered a public record. Another exemption relates to deliberative process. This is something that you see often in agencies that are trying to develop a policy regarding some issue within their jurisdiction. It might not be a public body like the way that we think of our select board or planning board, but maybe it's an agency within the state government that is trying to map out a certain type of policy. And what the deliberative process exemption says is while that process is playing out, those records are not considered public. So it allows the agency to have some control regarding its discussion and its developments regarding a particular piece of policy until that policy is complete or enacted, at which time the records then become public in the sense that this deliberative process exemption would no longer be applicable. Investigatory exemptions typically relate to information within, an example might be police reports that relate to, for instance, maybe CIs, confidential informants, or maybe the manner in which an investigation was conducted, or something else that law enforcement can say, if it were to be disclosed, would affect their ability to conduct future investigations, perhaps, that it would in some way sort of jeopardize perhaps the way that they conduct, let's say, surveillance, or it might in some other way frustrate the purpose of some future investigation. Then you can make an argument that those types of records or portions of those records would be exempt from the public record statute. There's also an exemption for records that relate to internal layout of buildings and facilities and infrastructure. This is an exemption that is in place to protect and promote public safety and even safety maybe outside of the context of just sort of public spaces. But the idea there is you don't want to be providing information, for instance, let's say regarding a bridge and where the support beams in a bridge might be that could be subject to some sort of tinkering or some sort of attack that could result in a horrible situation. So there is a provision within the public records law that allows for those sections of records to be either withheld or to be redacted. Again, the driving force there being one of public safety. More typical types of exemptions that you see just relate to trying to keep certain aspects of public employees, officials, appointees' lives. So while certainly the salaries of every public employee in the state are available to the public, their home addresses, their home phone numbers, their personal emails are not. So the law does try to sort of create a division between the public life and the personal life, and that's something that you see in terms of the application of an exemption in the public records law. You see that quite a bit. The last three are rather discrete in their application. Bid proposals, so if the town puts out an RFP, a request for proposals for a new building, and it starts receiving bids, those bids remain closed until a certain time as designated in the proposal documents, the request for proposal documents, at which time they're all open together. And so there's an exemption that applies from the public records law that applies to those bid proposals before they're opened, which makes some sense, because if the bids are opened on Friday, but some bidder submits their proposal on Tuesday, and a potential bidder wants to know what that bid looked like so that they can tailor their bid or put their bid in some amount of money less than what the other proposer might have offered, they would likely try to do that through a public records request. Well, you can't do that. So there's a specific exemption for bid proposals. Real estate appraisals, you typically see that exemption applied in a situation where a town is in active negotiation to either to purchase or to sell a piece of property. And just like a private party in a similar transaction would have the ability to get an appraisal and not disclose what that appraisal was to the party that they might be negotiating with, the town has the same sort of ability to do that. And there's actually quite a bit of overlap in some of these exemptions with the open meeting law in things, for instance, that our select board can do in executive session to sort of level the playing field, if you will, between the municipality and a private agency, so that the municipality isn't at a disadvantage if someone tries to get information from them about their negotiating position. So there's some overlap between those two different bodies of law. The last is trade secrets and confidential information. So this particularly applies in situations where perhaps, let's say one of our universities, for instance, one of our public universities developed a certain type of, a formula or a certain type of machine, and was going to go through the process of actually, seeking legal protections and securing their ownership rights in that formula or that machine. You wouldn't, the public records law prevents individuals from asking for public records that would disclose that. One example that jumps to mind is Gatorade, for instance. Although it's not Massachusetts, Gatorade was something that was developed by the University of Florida, I believe. And they currently, as far as I know, they still have that particular formula secret. It's theirs. The university owns it. So you take that example to Massachusetts, and if one of our schools were to develop something like that, and a public records law or public records request was made, there would be an ability for the school to apply an exemption and say, no, we're not going to turn over the secret formula to this thing that we've developed. I've never had to apply that to anything in Milton, though. We don't have any secret formulas here in the town that I can tell you about. So here are two that I think are interesting as well. The first is the notebook or other materials prepared by an employee which are personal to them. So this exemption applies when, let's say, a planning board member during a meeting takes notes of what was said during the meeting, and this is separate and apart from the meeting minutes, but maybe they're simply taking notes during a presentation that is being made by an applicant for some sort of permit. As long as that individual keeps those notes to themselves, and maybe they're using it because it's the application process, the hearing process for the application is going to be spread over many nights or perhaps weeks or months, and they want to be able to reflect back on different parts of the presentation when they ultimately discuss with their fellow board members whether or not to grant the permit, so long as their notes remain personal to them. In other words, they don't share them with everybody else on the board, and they just use them to be able to do their job, which is make a determination as a part of that group about a permit application, then those notes are not considered public records. Again, the line here is whether or not the notes are shared. If the notes are shared, then they're public. If they're not, then they're arguably not public records. The last exemption that I mentioned here is the attorney-client privilege. Obviously, the town has counsel. That is our firm. If the town is seeking legal advice from my firm, that is a communication that is protected by the attorney-client privilege, as is my response or any member of my firm's response to that request for legal advice. So the attorney-client privilege exists in the municipal world and the public records world in a very similar fashion to the manner in which it exists in the private world. If you have an attorney and you're asking them for legal advice and they're providing you with a response and they're providing you with legal advice, then those communications are protected by the attorney-client privilege. In the same way, if a member of the select board reaches out to me and wants to know in an email what my travel plans are for the holiday, and I respond and say, I'm going to go see family, that is not an attorney-client communication. In the same way, it arguably wouldn't, even if it was a private client speaking with their attorney, because if the purpose for the conversation, or the communication rather, is not seeking legal advice and the provision of legal advice in response to that request, then it's not protected by the attorney-client privilege. Again, some more exemptions here that apply to the privacy issues that we've discussed. There are exemptions specifically regarding records relating to who own and possess firearms. There are records that apply, public record exemptions that apply for personal information related to law enforcement, to the judiciary, and also to victims of crime. So from time to time, when a town or some other agency or municipality receives a public records request, the question is asked, why? Why have we received this request, and does the answer to that question have any bearing on what our rights are under the public records law? And by and large, the answer to that question is, it does not matter what the purpose of the request is. The exceptions to that are that if it is a commercial, if the request has been made for a commercial purpose, that is an inquiry, or let me back up. If a municipality responding to a public record request believes that the request may have been made for a commercial purpose, and I'll explain that in just a second, they can follow up and say, can you give me some more information about this request? Now, what you might see in this category would be sometimes you have either state or nationwide countries that are looking for public records that will support their business model, whether they be to obtain lists of individuals that might be prospective customers, or perhaps it relates to types of permits that were issued because a business might want to follow up with the individuals that were granted permits so that they could maybe solicit business from them, or something else that sort of sounds in the nature of trying to get information to promote one's business, or get information that is helpful to one's business. If that's the reason for the request, then a requester can take that into account. The individual responding to the request can take that into account, and with that information, they can make a decision about whether or not they're going to charge a fee for those records or not. And we'll get into that issue of fees and waivers of fees in just a moment too. But it's just, I think, important to call out here that the one of two times that the purpose for which a request is made can actually be sought is when, in the first instance, it might be for a commercial purpose, and the second is when you believe that the request is being made simply to harass. And under the statute, under 6610, Mass General Law 66, Section 10, the definition for harassment is quite broad. It needs to be part of a series of contemporaneous requests that are frivolous or designed to intimidate or harass, and that the requests are not intended for the broad dissemination of information to the public about actual or alleged government activity. It is the rare occasion when you see requests that don't that satisfy both of these prongs. And that is to say, it is very rare, and I mean incredibly rare, that the Public Records Division makes a determination that a request is simply harassing in nature. And when I say incredibly rare, if you think that every year there are probably some 2,000 public record determinations that are made by the supervisor of public records regarding a request, and then perhaps an appeal by the requester of the response to their request. Out of all of those appeals over the past 6 to 8 years, there's only been 2 or 3 that I'm aware of determinations by the supervisor that a request was actually harassing in nature. So it's incredibly rare. It's something that I think municipalities, for a number of different reasons, think that they experience when they receive a request, but the actual criteria for a determination that a request is harassing in nature under this statute is very, very rigid, and it is not often applied by the Public Records Division. All right, so these are the final topics that we'll just sort of cover in the next 10 slides or so. records access officers, production, timeframes, fees, the appeal process, and storage of public records. So every town or every municipal group or agency has a record access officer. By default, for municipalities, it's the clerk. Our clerk is Susan Galvin. The record access officer's role is to coordinate the municipality's response for public records requests. So what that often means is that when a public record request comes into the town of Milton, it is immediately sort of received by the clerk's office. It's logged by the clerk's office in software that the town maintains, and the clerk determines who will be best suited to respond to the public record request, or whether that is several persons that might be part of the response team, and then we'll coordinate with those individuals to make sure that the public response is made in a timely fashion. Under the statute, the RAO has a number of obligations to document certain types of information for the requests. What actually is being requested, when the request was made, when the response is provided, how long it took to provide the response, whether any fees were charged for the production of the records, and whether or not there was an appeal of the outcome of the production or of the response to the public record request. Under the law and under the regs, the default manner in which records are to be produced is by electronic means. That's not always possible. And where it's not, the municipality is entitled to simply allow the requester to come and view documents. So if, for instance, there were documents at town hall that were quite large, maybe plans, for instance, that were not things that could easily be reduced to an electronic format, then the town could simply say to the requester, we'll schedule a time and you can come in and take a look at these records. And the town has done that from time to time. The software that our town maintains to help it receive, respond, and record public record requests is called GovQA. It's accessible through the town's website. It's a really powerful piece of software that allows individuals to make a document request or make a public record request. It allows employees and myself and individuals from my office to see the record requests as they come in real time, upload documents that we believe are responsive, make redactions to documents where we believe redactions are necessary, and then produce the records through the system to the requester. And of course, all of that is then recorded, so some of the obligations of the clerk that were described earlier to keep track of these record requests is being done automatically through this GovQA portal. All right, so when a public record request is received under the public records law and the regs, there are a number of strict deadlines that need to be considered. Under the regs and under the laws, you have to respond to a public record request within 10 business days. What is a business day? A business day is Monday through Friday, except for holidays or days on which the municipality is unexpectedly closed. So if there's a snowstorm on Thursday night and Friday town hall doesn't open, Friday's not a business day. Thanksgiving is not a business day. Friday after Thanksgiving is considered a business day. It's not a public holiday. And frankly, if Milton is typically closed the day after Thanksgiving and has been for a long time, even though it's closed, it's expectedly closed. And so that day would arguably count as a business day. The 10-day business day deadline is important for a number of reasons. First, it's important to get a response out to the person that's made the request in a timely fashion in this 10 business day time period. In that response, you're supposed to identify whether or not you have records that are responsive, and you can also address the issue of whether or not a fee might be requested by the town to produce the records. So just to be clear, if a public records request comes into a town, 10 business days after the request, the town doesn't have to produce all of the records necessarily by that date. They could. They could say, we found 10 records and they're responsive to your record request, here they are. But maybe the town says, we found 50,000 records that are responsive to your request because of the way that it was written. And if you want us to produce those records, we're going to ask that you pay a fee. And then you would explain what your fee is. If you don't respond within 10 business days, a municipality loses its ability to charge a fee, which is incredibly important because sometimes these record requests that come in can be very, very broad, and they can put an incredible amount of strain onto town hall to produce records that are responsive. And so when the public records law was created, there was a provision, this provision included, regarding fees that allows the municipality to be able to offset or to be compensated for the amount of time it has to that it has to spend or to commit to responding to public record requests. But again, the municipality loses its right to ask for a fee if it doesn't do so within 10 business days. Again, just a bit more definition regarding what needs to be in the response. Within that 10 business day deadline, you might also say that the municipality needs more time to find documents that are responsive. Perhaps they're not electronic documents. A lot of times public record requests that come in are for emails. Our town has a system that catalogs emails and allows us to search emails, and that's relatively quick to do in terms of searching for the records. But the town maintains all sorts of paper records as well, particularly in town hall. And if there's something that's being requested that's in the paper files, that's in the vault or in some other area in town hall that's going to take some time to go through and find, the town can, among other things, ask for more time to be able to respond to the record request. It's also important, particularly where there's going to be a fee petition or a request that a requester actually have to pay a fee in order to get the records that they're looking for. The records access officer, which is our clerk, pursuant to the regs and to the law, is supposed to suggest a way in which that fee might be reduced. So if the response is, we received your request, we think we have 10,000 records that are responsive, it's going to cost us $10,000 to produce all of those records. Having said that, if you were to restrict the dates of your request or reduce the number of individuals from whom you're looking for these records, or some other way narrow the scope of your request, your fee might be reduced. That's something that the petitioner is obligated to put, that the record access officer is obligated to put into the request. And with good reason, because before that was in the law, there was a tendency, or at least the perception, that municipalities, when they would receive a request, would attach a hefty fee to their response, and that would be the end of it. Then the person requesting the records would simply, walk away from the request. And so this particular provision in the public records law was put there so that people that make a public records request and receive a response that it will cost them something to get those records are also given some information regarding options that they might take advantage of to get some of the records that they're looking for at perhaps a lesser cost than what's included in the initial response. It's also important for the record access officer to include a statement that the person making the request has the right to appeal to the supervisor of records. If a requester sends in a public record request to the town of Milton, and the town of Milton responds and says, here are some documents, or says, we have documents that are responsive, but we're going to request that there be a fee paid by you to receive them, or the town of Milton produces records, but there are redactions that are made to those records. If any of those three things happen, among others, that a person requesting the record disagrees with or challenges and says, no, these things shouldn't be redacted, or the fee shouldn't be this high, they have a right under state law to appeal to the supervisor of records. And not only is that right enshrined in the law, it's also required by the law that it be included in every response that every individual that makes a public record request receives. Again, regarding the time frame for response, the public records has the ability to extend the time to respond to records. It should go without saying at this point that you have to make that request for additional time in a timely fashion. In other words, you can't wait 2 months and then ask for 3 months more to respond. If you're going to ask for more time, you need to do so in a timely fashion. Just in terms of the fee structures and how that works, again, if a record access officer, like our clerk, receives a public record request, once they've spoken with an individual, the individual, or perhaps a number of individuals that have an understanding of what records might be responsive, they can start to determine how much time they believe it will cost or how much time it will take to search for the responsive records, compile those records, segregate those records, which just might mean that there are portions of the records that apply and others that do not to the request that was made, and potentially redact portions of those records and reproduce those records. Once the clerk has sort of considered all of those different pieces, the clerk can choose to request a fee from the person that has made the public record request. Now, the first part of that fee estimate is based on these things, about how much time it will take to actually look for and compile the records that are responsive and make any redactions that the clerk believes are necessary. The second part, though, of the fee structure relates to who's actually going to be doing the work. So in Milton, there are approximately, I think, just under 30,000 residents. Under the public record law, that means that we're not permitted to charge for the first 2 hours of any work that's done to comply with the public record request. But after that, the clerk can charge up to $25 per hour to complete any of those tasks that we previously mentioned, either searching or compiling or segregating or redacting records. Typically, the way that this is done is that the clerk, using their knowledge of where the records are and who's best suited to actually search for and compile the records, makes a determination about what that individual's hourly rate is, whether based on their actual hourly rate or if they're a salaried employee, then an approximate hourly rate. And if that rate is under $25 an hour, then the clerk may request that the person looking for the records pay to have that hourly rate paid for by the requester in order to complete a response to the request. From time to time, though, the person that's best suited to actually review the records has an hourly rate that exceeds $25 an hour. This comes into play from time to time when the records that are being sought are protected by, or at least in part by, the attorney-client privilege. And my firm's rate is in excess of $25 an hour. And if my firm is best suited to be able to make that determination, which it arguably is in all instances where the attorney-client privilege is being invoked, then the clerk can submit a petition to the Public Records Division and ask that a rate of over $25 an hour be charged in order to produce the records. Again, the RAO has some discretion here. If the RAO makes a determination that although she could request a fee, there's some good reason not to, then she may choose not to. Also, there are instances from time to time where you'll have serial requesters, individuals that make many record requests. And if you end up in a situation where there was a request, there was a fee petition that went out to respond to the request, and either the records were sent out at the same time that the fee petition was sent out, which sometimes happens. In other words, the clerk says, here are your records, you owe us $25. Or perhaps if the request was simply made, well, actually, we'll stick with that first example. If that happened where the records went out and the person was sent a bill but hadn't paid, If that person makes another request for a different set of records, the RAO can actually point to the first instance and say, you still owe us for the records that we produced to you that you haven't paid for us. And in that situation, they can actually hold back records until the balance is owed, or balance is paid on the first request. As I was saying earlier, there is an opportunity for an individual that makes a public record request to appeal the response that they are given to the supervisor of public records. This happens where either the town doesn't produce any records at all and just ignores the request, or where the town does make a response but the requester is not satisfied with that request. It goes to the supervisor. The supervisor, under state law, has 10 days to make a written determination, and then that determination is essentially an order back to the municipality either to clarify their response or produce the records immediately or some other thing. And while the supervisor themselves or herself doesn't have the ability to actually enforce the public records law, they will and have basically forward their request or notify the Attorney General's office of their order, as it were, to a municipality, which the municipality is ignoring. So the Attorney General essentially becomes the enforcement mechanism for the public records law when the supervisor issues a decision and that decision is either ignored or in some other way not followed by the agency that receives the order, the decision from the supervisor. Under the public records law, a individual who's not satisfied with the response that they receive from a municipality can actually choose an entirely different path from appealing to the supervisor of public records. Any individual that makes a public records request and is not satisfied with the response that they receive can actually file a lawsuit in Superior Court and seek help from the court to enforce the public records law, essentially seek an order from the court that the municipality do something, respond in some way to a public records request that they have either refused or failed to do. If an individual seeks relief from the court basically has the same ability to review the record request, the town or the municipality or agency's response, as the supervisor does. The court basically stands in the supervisor's shoes. It also sort of starts with the presumption that the records that are being sought are in fact public, and the stakes are raised considerably in this venue because if the municipality loses, if there's an order from the court suggesting that the municipality has not complied with the public records law, the possibility exists that the court might award attorney's fees and costs to the requester that would have to be paid by the municipality. That's not something that the supervisor can or does do. It's only something that a court has the authority to do under the public records law. So to that point, again, the court has this ability to enter orders regarding the documents that are being sought, regarding attorney's fees, and on top of that, if the Superior Court finds that a municipality acted in some manner that demonstrated bad faith, they also have the ability to award punitive damages of up to $5,000. So the stakes are quite high if a public record response is appealed to the Superior Court. But even with the presumptions in favor of a record being a public record, which seems to sort of put the municipality on its heels in any proceeding in the Superior Court, the municipality does have the ability to rebut those presumptions and to make out a case that it was, when it acted, however it did, in either producing certain records or making certain redactions or not producing other records, that it was acting in accordance with a decision by the supervisor of public records or by some opinion that the Attorney General's office had published, or by arguing that the request was made to intimidate or harass or for commercial purposes. So that is just to say, if the municipality can point to something in the court and say, we acted the way that we did because we had received a decision from the supervisor of records that said something and we based our actions on that, or the Attorney General's office had drafted this and published this opinion some time ago and we were relying on that opinion when we responded to the public records request. If it can do those things, then it can rebut that presumption that attorney's fees should be awarded by the court in favor of the individual that's requesting the records. So storage of public records is sort of a tricky thing. And the reason I say that is because what is often considered, or what is presently considered, a long-lasting form of electronic storage may very soon become, something of the past. And I was sort of reflecting on that today, and I have a briefcase in my office that was state of the art when it was made, and I know that because when you open it up, it says that this pouch is for floppy disks. And I thought that's, at the time, people thought floppy disks were the wave of the future, and for a time they were, but at some point they became a thing of the past. And so while it's incredibly tempting to say, well, why don't we reduce all of our public records here in the town to electronic format and we'll store them on floppy disks or hard disks or CD-ROMs or USB drives or the cloud, as those ways to store information continue to change, it puts in peril the municipality's ability to hold on to records that were kept on in earlier formats. For instance, had we stored all of our records on floppy disks 20 years ago, what would we do with those now? You'd be hopeful that you could find someone that could convert them or upload them to some other format, but there's always that risk. So it's a very challenging thing for municipalities to consider. Obviously, with the advent of email, the number of public records that municipalities are expected to maintain exploded. And so towns end up having to spend a considerable amount of time and money making sure that things like email are accounted for and maintained so that the town stays in compliance with the public records law. And it's a situation where the goalposts move rather frequently, and it falls on the clerks to make good decisions about what is the safest way for the municipality to be able to continue to maintain its records and be in compliance with the public records law. Again, just some additional responsibilities of the record access officer. They are to keep and publish under the public records law certain things like decisions and opinions from the municipality, whether they be from various boards or departments, annual reports, notices of hearings. The public records law expects the record access officer to take steps to put all of these things on the town's website, not only simply maintain them, but also maintain them in an electronic form on the town's website where they can be accessed by the public. Some other examples are bids for public contracts, the meeting minutes for the meetings of public bodies, budgets, lots of things. So it's not simply keeping track of the records that do exist, but there's also responsibility and obligations of the record access officer under the public records law to try to make these things, these public records that the town maintains, available to the public through the town's website. Two quick notes here on some sort of interesting areas of the public records law that relate to requests in the context, in this first instance, of litigation. It's often the case that municipalities that are involved in litigation will receive public record requests from the party that is opposite them in the litigation. And there's a very interesting play between sort of what information is available to parties in litigation from other parties. That's commonly referred to as discovery, one party asking another party for some type of information. And there are a set of rules in the courts that sort of provide a structure for the manner in which requests can be made for information and documents, and the manner in which things can be produced. And there's this whole framework in our rules of civil procedure that provide for that. But when a party in litigation is a municipality, it may also at the same time be subject to is subject to the public records law. So from time to time, where this comes up is you'll have litigation pending against a municipality. There are requests made within the context of the litigation and outside of the litigation by way of public records requests. So you'll have two avenues by which a party could seek discovery from a town or agency under two completely different sets of rules. In addition, you may also have instances where you have a matter proceeding in front of the supervisor of public records. Maybe there's been a request and an appeal to the supervisor, but at the same time that appeal was made to the supervisor, the person requesting the record also filed in superior court. So asking basically the supervisor and a superior court judge to weigh in on a town's response to a public record request. And what we've seen in those cases is that more often than not, the supervisor takes the approach that if the records that are being sought are subject to litigation or subject to discovery requests, the supervisor will defer to the court and say, we're not going to give you two venues in which to make these claims and to resolve these disputes regarding your request for documents. We're going to defer to the superior court instead. And so that sort of closes one of the two avenues that a party might have been trying to use to obtain information from a municipality, and simply just confines it to the litigation while that litigation is proceeding. After the litigation is over, then the public records avenue opens back up and they can request records that way. But at least insofar as the time period during which the litigation is active, it has seemed to be the case that the supervisor will defer to the superior court. And similarly, in situations where there's overlap between the open meeting law and public records law, the supervisor will often defer to the attorney general. So where this comes up is, let's say, for instance, that there is a request that's made for public bodies meeting minutes. Now, arguably, that request sounds like a public record request. Documents that were created by a public body. It certainly falls within the definition of a public record. However, there is a mechanism under state law, under the open meeting law within state law, that provides for individuals to obtain records from public bodies, whether they be meeting minutes or records that were used during a meeting. And when there's overlap, and this happens from time to time where someone, for instance, requests meeting minutes, they're not provided in a timely fashion, or they're provided and there's some question about the manner in which they've been provided, if there were redactions or if there was some issue regarding completeness. And the requester appeals that request to the supervisor of public records will often defer a determination on that issue to the Attorney General's office. And that really looks like a letter written back to the requester that says, the thing that you're asking my office to do is really more appropriately done by the Attorney General's office. You should contact the Attorney General's office. So that happens from time to time as well. So I believe that's the end of the presentation. We've gone quite a bit over, 50 minutes. But if there are any questions that anyone has, I'm happy to try to answer them. Amy.
So if you respond to a public records request saying that you're providing a cost estimate within the 10-day frame,
Yes.
but you don't hear back from the requester, when can you close that request? Does that remain open forever, or
Right.
is there a certain amount of time where you can consider that closed? And then part two is, in the past, I've done a cost estimate and it said, please send a check in. When I receive your check, I'll provide the record.
Yes.
Does that give me 10 more days
Wow.
to fulfill the request?
Great.
Once the check is received?
Yeah, those are great questions. So a couple of things to keep in mind. If there's a request that comes in and the response in the record access officer's opinion is going to necessitate a fee, the record access officer has to do two things within 10 days. They need to send a response to the requester, and they need to send a petition to the supervisor of records asking that they be permitted to charge a fee to produce the records, unless the records that are being redacted are required to be redacted by some provision of state law, which is usually like a student record type of thing. But if it's one of the exemptions, if it's in the applications of one of the exemptions, you have to ask for permission to be able to charge a fee to do that redaction and then provide the records. I don't know of any provision in the statute or in the regs that says that if you provide the petition and no one responds, that you have to sort of leave it open for a certain period of time. All I would say is that there's nothing in the public records law that prevents someone from making a new public record request at some later point. So sort of the opening or closing of it, I think, might lose some significance because someone could just ask for the same records again and you'd have to give them the same fee again. And I would advise against, if that were to happen, saying to the requester, well, I provided you a fee estimate back then, it's the same thing, and kind of leaving it at that. I think you would do the same thing you did the first time, where you respond and then you send the fee petition. So I think that's kind of the way that I would look at it.
So every time you feel a fee is appropriate, you have to request permission to actually say that?
You have to ask permission to be able to charge the fee to the individual. So you have to petition the supervisor to be able to charge the fee, unless the redaction is required. Because maybe I didn't make this clear, but not all the exemptions aren't all mandatory. So for instance, some of the personnel exemptions or the privacy exemptions, the town isn't required to make those. Under FERPA, under the student records law, the school is required by law to redact student records before they can be produced. If that's the case, then you don't have to ask for permission to charge that fee. You can just do that as a matter of course. But if it's discretionary, whether or not the redaction will be made, you have to ask for permission to be able to do that. And there was the second question was slightly different. I've just forgotten it.
If they send in the fee,
Yes.
how
Oh,
long do you have to
right.
actually use the record?
Right. So what I would suggest there is when you send out the request, when you send out your response, if you're going to be asking for a fee, you should include in your response how long it will take for the documents to be produced once you receive the fee. So I would typically say, I expect it will take me 10 days once I receive your fee to produce these records. So then you impose it. Otherwise, you might be in a position where you'd need to either seek some relief from the Public Records Division, having gotten your foot in the door by making the response in a timely fashion and making the fee petition in a timely fashion, and then receiving the money, but realizing then, wow, this is going to take me 3 weeks to produce. You'd be, I think, in good position at that point to say to the supervisor, we just got the fee petition and I need 2 more weeks under the statute here to be able to provide the records, and I think that is something that would be granted by the supervisor.
Thank you.
Absolutely. Any other questions?
Yes, has someone
Oh.
brought on? And I wanted to make some connection with town hall. Would I need to get a particular email?
Are you saying if you just wanted to make a request for a public record, or if you,
Right, you talked about personal emails.
Right.
And town emails. So
Right.
if this is as a town meeting member, I'm
right?
looking in for information, do I have to get a town email address?
I don't, you don't have to. And frankly, the question of whether a town meeting member's communications are public records would be something that I'd want to look at specifically on a case-by-case basis before determining whether or not they were public records. But for individuals that are certainly employed as, as full-time employees or part-time employees by the town, or members that are on boards within the town that have public email accounts available to them through the town, they should use those public email accounts exclusively when they conduct town business.
Just a regular, ordinary citizen who's a town meeting member.
Well, you're not subject to the public records law. If you just, any member of the town that requests, that sends an email, for instance, that's not a public record. You're not an employee, you're not part of government, that's not a public record. If you sent an email to the town asking for a public record, arguably your request might be considered a public record because it's received by the town, but the town would then be obligated to maintain that. You would not be. You're not, as a private citizen, you're not under any obligation to comply with the public record law in your private citizen capacity. Right.
A lot to learn.
There certainly is. Do you have a question too?
Yeah, what about entities like the police and fire?
Yes.
You had questions, not regarding like specific cases, let's say police, but, you just want information on arrests or fire, statistical information.
Mm-hmm.
Is that requestable, and who would you go to?
Yes, it is. And in Milton, the police department has its own records access officer that coordinates all the responses from the police department. There are obviously provisions in the open meeting law that deal more specifically with investigations that we were talking about tonight, and also information regarding law enforcement personnel, their home addresses and email addresses, things of that nature. And the individual at the Milton Police Department is very well versed in those particular areas, and that person coordinates the response. So when a public record request is sent to, or sort of made to, the town of Milton's police department, I very rarely see it, if at all. That's usually handled entirely in-house. In the same way that requests that are made to the school, for instance, the schools, those are handled internally by the schools. They have their own mechanism for dealing with it. It all may flow through our portal, the GovQA portal, but ultimately there are individuals in each one of those groups that are assigned to and responsible for responding to the public record requests.
Do you have another person that's police?
I don't. John King, the chief, would know for sure, and I know that I've dealt with the person from time to time because we've sort of collaborated on ideas and responses, but I don't know their name off the top of my head.
Can I add something?
Sure.
So I don't know the name of the person, but if you go on the town's website, there is, I believe, a public records request link, and if you click on there when you start to create your request, we'll say, what department are you requesting your records for? And I believe there's a choice of school, town, and I think police is on there as well, and that would send an electronic email to that person. I believe it should probably also be on the police web page of the website. Almost positive it's on there, but,
I'm sure I did that, you could just email.
yeah, and that works too, right? Like, you
That
don't
does
have
work.
to go through the GovQA system.
That's right.
As an employee responding to a records request, I'm required to respond through there, and often what I'll do is, some people aren't comfortable with that system, so I'll log in the request. I'll send the responsive records via email, but I'll say you're also gonna get an email from the system that says responsive
Right.
records are available. And then in my email, I'll say it's exactly what I'm attaching here, so don't feel obligated to go into that system. But in order for Sue Galvin, the town clerk, to have an accurate record of what I'm responding to, she requests, or the procedure within town is that we are supposed to respond through that system,
Right.
so it's logged in. But we are not, you can request to get it in paper, you can request to inspect, you can request via email, right?
That's right.
That's up there.
Can you repeat that? Are you required to? Did you say you're required to respond to the system, or not necessarily? It's encouraged, but is it required?
As a requester, you are not required to go through that. You could call me.
Yeah, someone could,
Correct me if I'm wrong.
someone could walk into town hall tomorrow and make a record request at the clerk's office. Best practice is to reduce that request to writing so that it's clear what's been made, but there's no requirement under the law that says that it has to be made in any one particular format.
What about now response? Like, I've emailed people for information, I've gotten responses back without an accompanying record being made in the.
Yeah, so it's not required under state law that it go through GovQA, but Milton it sort of follows a best practice here of trying to have all records, even because they can be made directly through GovQA, or they can be made in an email, for instance, the clerk. Either way, they should end up being logged in GovQA, and the responses get logged in GovQA, so that a year from now we can look back and say, oh, this request was made, this is what was produced, and that's the end of it. But there's some record there of it.
And if you're not getting an email from that system, it could be that the employee that's responding to you, there's an option, send email, so you can suppress that. So if they know that they already responded to you via email, they may not be generating that automated
Right.
response to the system, but are probably still logging it in there.
Yeah, there are a number of automated responses from the system sort of identifying when requests come in, but there are individuals that have had issues with our system, and so they're entitled to public records just as much as individuals that don't have any problem with the system. So when they ask for public records, sometimes they'll say, I'd like these provided directly to me by email, not through the portal. We do that. We provide them to them directly, but we also try to upload whatever that response is into GovQA so that there's a record of it in GovQA as well.
Clarify your response to the question up front. Is the PRR itself a public document you're saying, and I know that's constituted the
Yep.
appended, or?
As far as I'm concerned, it is. If I make a public record request, that's a public record. Having said that, there might be pieces within it that might be, something that would be redacted. For instance, I think the supervisor takes the position that a person's private email address is something that can be redacted under the privacy exemption. So if I, from my personal email address, make a request to the town of Milton for documents, and then someone says, I'd like to see the request that Kevin made, it would be, I think, appropriate for the town to produce that request, but to redact my personal email address from it. And that's, the issue there is whether the person that made the request had some expectation that their personal email address wouldn't be shared with the whole world. And I know the supervisor takes the position that one does, and it kind of promotes, in a way, people asking for things to think like, maybe someone can find out what I asked for, but they won't get my home address and my telephone number. It's the same way a lot of people have their home address and telephone number on a signature block in their personal email accounts. And when, I've had public record requests that include documents that have emails just like that, where it'll say, John Jones at 123 Center Street, and here's the email address and cell phone. And I think it's appropriate to redact a lot of that information because that's not something that person, I think, thought they were publishing to the world when they asked for a public record.
So can you actually search on a person's name or issue a PRR about a specific person?
Sure.
Then if you had issued a previous PRR and the results contain names that would be redacted, you can get around that by issuing another.
So that's actually a really good question. So that's, you see that sometimes when someone might know that someone might have enough information to know that if they make a request for something and there's a response given, even if the information, like let's say that there was an individual who, resigned within the past couple of months, all right? And everybody knew that there was only one person that did. And there was a public records request that said, I want every document related to anybody that's resigned in the past month. Now, setting aside whether there would be issues with the personnel exemption, if you were trying to do exactly what you're saying, which is kind of get at, you don't need the person's name. They can redact the name out of the document because you know it's only about one person, right? The public records law, at least insofar as the supervisor is concerned, does take this sort of totality of the circumstances into mind when you produce records. And if there is no way for you to produce the document without disclosing what would otherwise be private information, then you might be able to withhold the document. This comes up, for instance, with in the student context. Like let's say that there was a situation where there was one student in a class that was on an IEP. And you said, I want all the documents that relate to any IEPs for any child in the schools. And there's only one person. And everybody, and there's reason to believe that the requester knows that. And again, there aren't any bright lines here necessarily. The supervisor looks to record access officers to kind of make determinations based on their best efforts about these things. But the supervisor or a public records response, or person responding to that record request could say, we're not going to produce any records because we know that even if we produce this record to you and we redacted that student's name, you know who the student is already. So it would be futile. It would be the same as if we hadn't redacted it. You'd still get everything else. So in that context, which doesn't happen very often, but when it does, it's definitely something that the town can consider and try to make its best determination on. And by the way, that's kind of why there's this appeal process with the supervisor where if the requester isn't satisfied with that, it goes to the supervisor. The supervisor looks at it and says, yeah, I think the municipality did the right thing, or I don't know what the municipality did. You need to give me some more information about what your response is because I don't understand it. And there's this back and forth. There's a dialogue that takes place where the supervisor is trying to kind of get the municipality and the requester to a point where they can have some understanding of what's being produced and whether or not the public records law is being followed. So, any other questions? All right. Well, thank you all for coming tonight. Happy Thanksgiving.